In this past term, you might be surprised to learn there were just under 1 out of 5 opinions that were split for 3. That tells me that really there are a fair number of unanimous opinions and splits of a lesser degree coming from our court. In contrast, at the U.S. Supreme Court, fully a third of their opinions are under some form of a 5-4 split. For whatever the reasons, we are seeing a little more cohesive view of the law here from the Wisconsin Supreme Court, and I think that's something that lawyers would like to share with their clients, especially if you have a client that is considering filing a petition for review. Hello, I'm Beth Hannon. I'm an appellate lawyer at Gass Weber Mullins in Milwaukee. I'm here to talk to you about a few of the highlights of an article I wrote for the December issue of Wisconsin Lawyer, describing some of the significant decisions, at least as I find them, of the Wisconsin Supreme Court from our recently concluded term. Now, it's just been a few months since that term closed, and it was a term that saw opinions across a fairly wide spectrum of substantive issues. One of the most difficult cases that the Supreme Court addressed this year had to do with surrogacy. 2 couples entered into a contract that they called a parentage agreement so that the wife in one of the couples could bear a child that would be raised by the other couple. The case is called Rozecki versus Schissel. Perhaps not surprisingly, things did not go as smoothly as these couples originally envisioned it. Their relationship broke down, and so by the time that the child was born, the birth mother, who had agreed to be a surrogate, had reconsidered her decision to terminate her parental rights. And termination of her rights had been one of the terms of this parentage agreement that the parties and their lawyers had worked out. The Supreme Court first acknowledged that there are no statutes that directly control the outcome in this sort of circumstance. TPR statutes don't directly address what rights the non-birth but adoptive mother would have in this situation. The court also looked to other states to see if they had surrogacy statutes that would give them some direct guidance on this, but did not find them. The court then went to consider principles of contract law, and that's ultimately where the majority, in an opinion written by Justice Ziegler, came down. Under the principles of contract law and the goals of the parties as evidenced by the terms of the contract, the majority felt that the bulk of the contract was enforceable. But because the provision that required termination of the birth mother's rights conflicted with the statutory procedure for TPR, that segment of the contract was unenforceable. The court then determined, again using contract principles, that that portion could be severed, leaving the balance of the contract enforceable. At that point, the Supreme Court remanded so that the Circuit Court could address the usual considerations under a TPR situation, as well as best interests of the child. There was a dissent written by Chief Justice Abrahamson, somewhat lamenting the application of contract principles without more, essentially. The dissent regarded this situation as leaving a child who is born of this type of circumstance to have different rights than other children, and that in fact this majority decision may leave more questions open than it has answered. So part of the reason I selected this case as one of the 9 most significant decisions is that I think we will see both our courts and our legislature struggling with more of these questions where technology allows families to be created in different ways, and where do the rights lie. The second case I wanted to highlight for you concerns an involuntary medication order, and in particular the statutory standard by which a court determines if a mental health patient is competent to refuse medication. In the case of Outagamie County versus Melanie L., the Supreme Court determined that the circuit court had misstated the standard under a 1995 statute for determining competency to refuse medication, and that the county therefore had not met its burden of proof to establish that the mental health patient was not competent to refuse her medication. The opinion is a pretty thoughtful treatment of the history in Wisconsin of statutory rules for involuntary medication administration, and a development in part based on challenges to earlier statutes of better protecting the due process rights of mental health patients when they are able to competently understand their condition, understand alternatives to treatment, and then make a decision whether or not to accept that medication. I go into greater detail in the December issue article about this case, and there is a dissent, which is also worth reading, and I think reflects perhaps a desire to get back to the earlier statutory standard. But I think it's significant for practitioners of all practice areas to read this case, in part because of the larger mental health care treatment discussion that is going on in our country. And I do think that our courts in Wisconsin will be called upon to address continuing issues of appropriate treatment, ability to reject treatment, and as citizens, it's worth knowing where our legislature and our courts stand on these current standards. Thank you.